Court calls the case, People versus Brandon Jeevers.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Chelsea Deals with and on behalf of Brandon Jeevers. Please state your name for the record.
Brandon Jeevers.
Thank you, sir. You're requesting an adjournment now.
We are, Your Honor, for discovery purposes, and I would also ask to briefly address bond.
Before we even reach the bond discussion, the defense is already planting seeds for leniency, highlighting the defendant's sobriety, stable lifestyle, and ties to the church. But in a courtroom, character only gets you so far. The real question is whether any of that outweighs the gravity of the accusations.
Probable cause conference in this matter will be adjourned to March 20th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, we are requesting release on tether, a personal bond with a tether. My client, we have information that the complaining witness has left the state. He would like to go back to his home. He's very concerned about losing his home and his car, essentially most of his life in custody for longer. He's involved with this church. He's sober, and he understands he has to come to court in the future. So we're asking you to consider release on a tether.
Response.
Your Honor, I would object to any modification of bond. In this case, the victim had been trying to leave the defendant because he had been mentally and verbally abusive. He became upset at the victim, pushed her on the bed, grabbed her neck with both hands, and strangled her. He was holding her down on the bed, and the victim described it as he was staring through her as he was strangling her. Afterwards, she thought she was going to die, and she wanted to call police, but she was afraid he would hear her. So she then drove to the police department to report the strangulation. She had red marks and scratches on her neck, and she said during the strangulation she began to lose consciousness and couldn't breathe, and remembered the defendant saying he would kill her. So I have very extreme concerns for her safety, even though she might not be in the state.
Did you catch that? The prosecution isn't just asking to deny bond. They're painting a chilling picture: control, violence, and a near-death experience. Strangulation isn't just assault. It's one of the most dangerous signs in domestic violence cases. The victim thought she wouldn't survive, and legally, that speaks volumes.
Because of this event, Your Honor.
Anything else?
We're aware of the allegations in this case. I do think that a tether to his residence would protect both the complaining witness and the community in this case.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case, People versus.
Now we move to another defendant, but notice the pattern. Similar charges, similar fears: domestic violence, intimidation, and control. As you hear each case, ask yourself, should these individuals get another shot on bond, or is the court right to keep them locked up?
Johnson.
Alexander, on behalf of the people.
Ryan Bowling on behalf of Mr. Defense. Just state your name for the record. William Johnson.
Thank you.
Your Honor, we're asking for this matter to be set for exam. To my knowledge, all discovery is complete.
People have their witnesses available the 18th.
We'll try our best, Your Honor.
Preliminary examination in person will be set March 18th, 2025, 9 a.m. That's before Judge Barr.
Your Honor, may I address bond?
Sure.
Thanks, Judge. Mr. Johnson is asking to be released. He indicates to me that he can reside with his mother in Charlotte. His mother is here in the courtroom, and she confirmed that today. He also indicates to me that he has a job that is waiting for him, or at least potentially waiting for him at a wastewater treatment plant in the Charlotte area as well. He's 33 years old, has 5 children, none of them with the complaining witness in this case. There'd be no reason for him to have any contact with the complaining witness. He would comply with all the conditions of bond set at his arraignment. So we'd ask the court to consider releasing him on a personal bond with tether of people.
Your Honor, we would be opposed to any modification of bond. In this case, the argument began, the victim was trying to avoid the defendant, and he ended up going outside, coming back inside, beginning to yell and spit in her face. And then had distracted him with opening to try to get him away from her. He then threw a bottle of hot sauce, a can, and a shelf at the victim. She then went to her daughter's room to get away from the defendant. He then kicked open the door to that room, pushed the victim into a wall, and began to strangle her with both hands around her neck and holding her up against the wall. She had to trip him to get away. He then began kicking and stomping on her ribs, and she started having trouble breathing after that as well. And her daughter had to call 911 to get the assault aside.
Listen closely to what's being described: strangulation, breaking into homes, weapons, injuries, sheer terror. These aren't one-off incidents. They're part of a dangerous cycle. Judges take this seriously because when a pattern forms, especially with kids around, the consequences can be deadly.
Great concerns, Your Honor.
Anything additional?
Nothing further, Judge.
Motion for bond reduction is denied. Bond will.
Thank you.
Thank you, Your Honor.
Court does call the case People versus Johnny Bankhead Williams.
And then on behalf of the people,
Stephanie Cannon on behalf of the Bankhead Williams, who is the train.
You're requesting an adjournment.
Yes, Your Honor. I'm requesting a 2-week adjournment. I did ask for a lot of, I believe this is the case where I emailed for a lot of discovery in this case. And it's also my understanding that DNA has been missing. I'm sorry. Are you?
Different case.
Oh, no, Your Honor. I just emailed for discovery.
March 20th, 2025, 9 a.m. Bond will continue.
Your Honor, could you entertain client?
Pardon?
Would you be willing to entertain tethering for my client to his home address? No?
You're making a bond request?
Yes, Your Honor. You hit the thing really quickly. You went quick. You said everything really quick.
Well, make your argument.
Thank you. Your Honor, in this case, my client actually does not live in this area. He lives in the Detroit area. He has no desire to be anywhere near the address where this incident occurred. He can be tethered to the Detroit home, ensuring that the complaining witness will not have any experiences with him during that time frame, and he's asking for that opportunity.
Your Honor, the people be opposed to any bond. In this case, the defendant had been trespassed with the victim's residence and returned and tried to break into the residence. He broke her storm door trying to get in, and only stopped when he saw police. He was found with a knife in his pocket, and he was by the residents and hiding under their bed, scared. He also has a previous history of a conviction for felony firearms and an armed robbery in 2017. I had great concern for her safety, given that he had already been trespassed from that residence and went back to that residence.
Anything else?
Your Honor, he could have, they were having contact with her consent. So when he did go back, he had something at the house. He just wanted it back because he had been there previously, Your Honor.
Motion for bond reduction denied. Bond will.
Thank you.
Court calls the case of the People versus Tyve Mills.
Andrew Childers appearing on behalf of.
Hey, good morning, Your Honor. Attorney Kevin Bassant, P71061, on behalf of Mr. Tyve Mills. Mr. Mills, please state your name for the record.
Tyve Mills.
Thank you. And Judge, just for the record, Your Honor, I did substitute in on all three of these matters very recently, Judge. I would just ask I be assigned to each case, Your Honor.
Well, you're retained.
Retained counsel, Judge.
Do I have the orders?
Well,
okay. All right, you're in.
thank you, Judge.
So you're requesting an adjournment?
I am, Judge. Today's date and time scheduled for PCC. I need discovery in all three cases, Judge, so we're asking for a new probable cause conference.
You want 2 or 3 weeks?
Judge, can we get 3 weeks, Your Honor?
Probable cause conference will be March 27th, 2025, 9 a.m. Bond continued.
May I very briefly address bond?
Briefly.
Judge, just very briefly, Your Honor. My client, he's 20 years old, Your Honor. He did have a prior case, but that was under HIDA. He successfully completed that. Judge, I understand these are very serious charges. The bond is $250,000 cash surety. I would ask the court to consider, at the very least, Your Honor, a 10% condition with a tether, Your Honor. His family is in court. He was working prior to being arrested in this particular case, Your Honor. He would have no contact with the law, and with the tether, he can be monitored and tracked, Your Honor. So we're just asking for a 10% provision with a tether.
Response from the people.
Your Honor, the defendant was charged in, I believe it's 25 F10203 with, among other things, possession with intent to deliver meth, felony firearm. The defendant was producing block switches using a 3D printer as well as ghost guns. When the police went to arrest him on that warrant last week, he attempted to flee, crashed into an MSP trooper, was involved in a chase with Pittsfield police. When they eventually apprehended him, was again found in possession of a firearm. During that chase, subsequently searched his home and found more with, I guess you would call molds in producing these ghost guns, as well as suspected controlled substances. So obviously, he's not only a danger to the community, but also a flight risk. I'd ask that bond remain as currently set.
Anything further, Chris?
Nothing from defense counsel.
Motion for bond reduction is denied. The court does consider the defendant a danger to the community and certainly a flight risk also. Bonds will